All right, welcome. This is a technical guide from us at Legal English Innovation, and today we're diving into a skill that's absolutely critical for any international lawyer: how to talk about the complex story of privacy law with total, pinpoint precision. Look, this isn't just a history lesson. This is about mastering the language you'll use every day in your client communications. Let's get started. So here's the thing. You know the law, right? You've spent countless hours on the landmark cases. You know the statutes inside and out. But the real test, the real challenge, is taking all of that, decades of legal change, and turning it into a clear, confident update for your client. How do you make that history matter to them right now? Well, that's exactly the skill we're going to master today. You know, to really speak about the law with authority, you have to understand its story. The law doesn't just appear out of nowhere. So we're going to use the evolution of privacy as our case study. We'll trace it all the way from a philosophical idea to the fundamental digital right it is today. This context, it's the bedrock for all the legal vocabulary we're about to build. Okay, this timeline is so much more than just a list of dates. It's really a map of how the law has responded to massive societal changes. Think about it. We go from 1890, a response to the new threat of photography, all the way to 1948, when privacy is recognized as a basic human right after World War II. Then, the 60s give us the reasonable expectation of privacy standard, a brilliant, flexible concept that we still argue about in court today. And of course, the digital explosion of the 90s and 2000s completely changed the game, leading to things like GDPR and CCPA. These regulations set a whole new global standard. So every point on this timeline isn't just history, it's a legal precedent you need to be able to explain clearly. This right here, this is where it all started. The right to be let alone. This one phrase, written way back in 1890, is still the core idea, the very heart, of our modern privacy torts and constitutional rights. When you're explaining a complex privacy rule to a client, trust me, starting with this simple, powerful concept brings immediate clarity. All right, with that historical map in our heads, let's get to the tools of our trade, the words themselves. Because in legal practice, being precise isn't just a nice to have, it's a must-have. It's everything. So let's build out the essential vocabulary you need for any serious discussion about privacy law. First up, constitutional privacy. Think of this as the highest level of protection. It's what safeguards us, mainly from the government stepping over the line. When you use this term, you're signaling that we're not just talking about a regular statute. We're talking about a fundamental right that's baked right into the country's constitution. Next, we have common law. Now, what's really important to get here is that the first privacy protections weren't written down by politicians. Nope. They were hammered out in the courts, case by case, decision by decision. This is what we call judge-made law, and it's the foundation of so many legal systems. And this brings us right back to the right to be let alone. A privacy tort is the legal tool, the cause of action. It's how a person can actually go to court and get a remedy when someone violates their privacy. For your clients, this is where the rubber meets the road. Understanding torts means understanding their potential liability. Finally, let's talk about these two, surveillance and wiretapping. These are the very actions that modern privacy laws are designed to control. It doesn't matter if it's the government or a private company doing it. These terms describe the specific activities that trigger a legal problem. They are, if you want to get technical, the actus reus, the wrongful act that the law is trying to prevent. Okay, now we're getting to the engine of your explanation, grammar. I know, it might not sound as exciting as legal theory, but getting the grammar right is what makes your advice clear, professional, and really truly authoritative. Let's start with how to talk about the past. The phrase used to is such a powerful tool in legal English. When you say, companies used to sell customer data, you're doing so much with so few words. You're painting a picture of the past, and at the same time, you're implying that things are different now. It's incredibly efficient. On the flip side, saying websites didn't used to display privacy policies instantly highlights a new duty, a new obligation that exists today. This is the key to showing that legal evolution to your client in a way they'll get immediately. Okay, now let's zoom in a little. From the big picture to the tiny details that make all the difference. In legal English, small words like prepositions, they carry a ton of weight. They define the relationships between ideas, and honestly, mastering the difference between to and for is a sign of true linguistic precision in our field. So, let's really break this down. Take a look at for. It's all about purpose or responsibility. Arguing for greater protections tells us the goal. Responsible for safeguarding data clearly states a legal duty. Now look at 2. It shows direction or connection. Crucial to the case links the evidence directly to the case. Prior to collection sets up a sequence, first consent, then collection. Using the wrong one can create ambiguity, and as a lawyer, ambiguity is your enemy. This is all about being crystal clear. So we have the history, we have the vocabulary, and we have the grammar. Now let's put all the pieces together and focus on the most important part of your job: clear, effective communication with your client. Here it is, a simple 3-step playbook for your next client update. Step 1, frame the past. Use that used to language to set the scene. Step 2, explain the present. This is where you talk about the new law, the new reality. And finally, step 3, state the implication. This is where you use our prepositions with precision. You explain why this change is crucial for your client and what it means to their compliance strategy. Just listen to how this all comes together. Hi, Bill. Wanted to quickly walk you through some key shifts. Organizations used to sell customer data pretty freely. Well, under GDPR, that's no longer the case. This change is absolutely crucial for your compliance strategy because consent is now required prior to any data collection. See that? It's clear, it's confident, and it shows your client immediate value. And that brings us to the end of our session. Look, the law is always changing, especially in fast-moving areas like AI, biometrics, and surveillance. So the real question isn't what we talked about today, but what comes next. With these tools in your pocket, what is the next big legal shift that you are going to have to explain? Mastering this language isn't just an exercise, it's absolutely essential for your continued success.